morning, ladies and gentlemen. This is my 14th video with regard to a case that I filed at the United States District Court in Orlando, Florida, as far back as on 1982. For the past 38 years, the defendant in this case, they were playing all kinds of dirtiest tricks, not dirty, dirtiest tricks, which I am going to explain in a moment. But let me take you first what the Supreme Court of the United States did in my case. On October 2, 2017, the Supreme Court of the United States issued. We are going to give you a close-up of what the court's order is. This is the insignia of the Supreme Court. The order reads, the motion for leave to proceed in forma pauperis is denied and the petition for a writ of mandamus is dismissed. The sentence is not over. It's a 5-line order. Continue. See Rule 39.8. As the petitioner has repeatedly abused the court's process, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with the Rule 33(1). That's the court's order. Folks, we will give you a close-up of the court's order so you understand, as educated people, how to read this. Unfortunately, the two clerks employed by the clerk of the Supreme Court didn't read the whole order. The first clerk, a woman by the name Melissa Blalock, she read a different case number 15-9100. That is not the case the court has decided. The case number is 16-9624, as shown on the first line, top line. So, this woman returned the entire brief, 40 sets of brief. You will see the brief, the big brief, the set of brief, 40 of them, which cost me a fortune to send it to the United States by Federal Express. She returned that check and the brief back, telling me to read the court's order. And my brief that I filed is in respect of the court's order. She's so stupid. She read part of the court's order. She referred to another case which was dismissed earlier. I sent the check back to Chief Justice Roberts, John G. Roberts, requesting him to direct the clerk's office to do the needful. Before doing that, as soon as I got the letter from this woman, her name is Melissa Blalock, this is her letter dated January 17, 2018. You will see close-up of the letter. She says, the above entitled petition for an extraordinary writ of mandamus was received on January 17, 2018. The papers are returned for the following reasons. Now she is giving the reason. Pursuant to the court's order of October 2, 2017, the clerk has been directed to reject your petitions in non-criminal matters unless you pay the docketing fee required by Rule 38 and submit your petition in compliance with Rule 33. She is telling me what is in the order, and what I have done is complying with the court's order, submit the papers. So this idiot, she doesn't understand, but she makes a blunder. She says in the caption, in re, case number 15-9100. That's the case. I want you to have a close-up of this so the viewers can see what is going on. So, her ignorance to read the correct case number is not my fault. As soon as I received the papers and the check back from her, I tried to call her. On her number listed here on this letter, which is 202-479-3023. That's my P3 exhibit. She won't answer the phone. She left a message on her voicemail telling me to leave a message for her, which I did 2 or 3 times. She won't return. Then I called her supervisor. I'm told his name is Jeffrey Atkins. He won't even read my letter or return my call. As soon as my complaint to the Chief Justice was received, Jeffrey Atkins, the next clerk, deputy clerk, he sent me a letter dated February 16, 2018. You will see the letter close up. He says, Mr. David, now he is putting the right case number, 16-9624. The other woman was putting the wrong case. She is reading the right case, putting the wrong case. This guy is writing the right case, but hear what he says. In reply to your letter or submission referred to this office by the Chief Justice on February 16, 2018, I regret to inform you that the court is unable to assist you in the matter you present. On October 2, the court dismissed a petition for a writ of mandamus in the case number 1694. This case is considered closed in this court. Your papers are herewith returned. Your 300 check is also enclosed, is returned herewith. This is what he is saying. So this super idiot, he only reads the court's order, the first line. He refused to read rest of the sentence, which tells me to submit the papers and the money, which is what I did. Okay? Now, I sent a letter of complaint to the chief clerk. Chief clerk is the person who meets the justices every day, the Supreme Court justices. He advised the court which case should be heard, which case should not be heard, for political reason. The United States courts is a political court. It hears, unlike in India, only 80 cases in a given year out of 10,000 or more cases filed. 80 cases. There is no justification whatsoever for the court refusing to hear the 9,200 cases out of 10,000 submitted to the court. Now, in response to my complaint to the chief clerk, his name is Court S. Harris. You will see his picture. A nice looking gentleman. He is a highly educated guy. He graduated from at Yale University in 1988. And he entered the University School of Law 2 years later, earning his Juris Doctor in 1993. He was admitted to the bar next year. Okay, that's his qualification. He is the chief clerk who sees every day the justices to tell them which case to be considered and which not to consider. Now, in response to my complaint to him that these two clerks, deputy clerks, Melissa Blaylock and Jeffrey Atkins, had goofed because the first clerk was looking at the wrong case, returning the papers and the check. Second clerk is only reading first line of the court's order, not reading lines 2, 3 and 4 and 5, which says, Mr. David pay the fee and file the brief. So the second idiot, Jeffrey Atkins, he doesn't want to read what is in the 5-line order of the court. You understand how illiterate that guy is? So I wrote to the chief clerk, Scott Harris, to look into this. Oh, I'm getting another letter, not from Scott Harris, from the same guy, Jeffrey Atkins. His letter dated April 10, 2018. Want to shoot it here? Close up. Let me read from the letter. He says, Dear Mr. David, in reply to your letter of submission received April 9, 2018, I regret to inform you that the court is unable to assist you in the matter you present. Paragraph. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases or controversies properly brought before it from lower courts in accordance with the federal law and filed pursuant to the rules of this court. Your papers are returned herewith for the reasons stated in the January 17, 2018 and February 16 correspondence. This Scott Harris, this guy is signing on behalf of Scott Harris, the same idiot Jeffrey Atkins. Now he is not the counsel for the defendant. They had 3 largest law firms in America. One of the law firms by the name Fulbright and Jaworski, currently known as Norton Rose, Fulbright and Jaworski, having more than 30,000 lawyers working 24 hours in 3 shifts. They didn't bring it up. There's another law firm in Florida. They didn't bring up. There is no delay on my part. And the rules say if the court had no jurisdiction and it considered the case, its judgment is a nullity. You understand? So this guy bring in cock and bull arguments to avoid consideration of the court's order dated October 2, 2017. Folks, I wrote to the chief clerk again, Scott Harris, who is the head of the department, the entire Supreme Court, Supreme Court clerk's office. Now I'm getting another letter from the same Jeffrey Atkins, this super notch idiot, working in the clerk's office. Now he says, Mr. David, your papers received again on June 26th and July 30th are returned herewith for the reasons stated in the January 17 and February 17 correspondence. Copies are attached. There's a close-up of the letter. So, what this super idiot is telling the world and me is whatever decision the first woman, Melissa Blaylock, had done, that's right in his determination, and his own decision. He says your papers are returned herewith. The Supreme Court says, Mr. David, file the petition, pay the fee, which is what I did. Okay? So, these idiots were playing Mickey Mouse games. I wrote to the Department of Justice, who has complete jurisdiction. There is a letter from the Department of Justice dated March 4, 2019. There is a close-up of this letter. Now let me read this for the benefit of the public. Dear Mr. David, thank you for your correspondence received December 12, 2018. The U.S. Department of Justice DOJ Office of the Inspector General investigates allegations of misconduct by employees and contractors of DOJ, as well as waste, fraud, and abuse affecting DOJ programs or operations. The matters you raised are outside our investigative jurisdiction. Therefore, no action can be taken by our office. We are returning your materials to you so that you may pursue your concerns in more appropriate venue. You may wish to consult the website www.ignet.gov to obtain contact information for other federal agency inspector general. Please be advised that we have not retained any copy of your materials, and the additional materials you submit regarding this matter will be destroyed. Of course, if you have new information that involves other allegations or issues regarding DOJ employees, contractors, programs, or operations, please feel free to submit that information to us. Thank you for giving us an opportunity to review your concern. That is a letter from the unsigned letter from the Office of the Inspector General of the U.S. Department of Justice. Okay? Now, I get another letter from the same agency saying that, I'm reading the letter dated April 11, 2019. In the letter, close-up of this one, the letter reads, Dear Mr. David, thank you for your correspondence dated March 18, 2019. The U.S. Department of Justice, DOJ, Office of Inspector General, investigates allegations of misconduct by employees and contractors of DOJ, as well as waste, fraud, and abuse affecting DOJ programs or operations. The matters you raised are outside our investigative jurisdiction. Therefore, no action can be taken by our office. As a courtesy, your complaint has been forwarded to the following office: Administrative Office of the United States Courts, 1 Columbus Circle Northeast, Washington, D.C., 2002. This office considers this matter raised in your most recent letter and in the previous correspondence to be closed, and we do not intend to exchange further correspondence with you regarding this matter, not signed, from the Office of the Inspector General of the U.S. Department of Justice. So what they are saying is, although these are corrupt employees of the court system, they do not have the jurisdiction to investigate them. Understand the name of the game here? Now, I did my own investigation. AT&T was found one of the top violators of the DOJ programs. This is Exhibit P9. Close up, please. This is page 1. Page 2, the number of cases DOJ investigated against AT&T. Page 2. Page 3. DOJ is, AT&T is one of the 87th contractor working for the U.S. Department of Justice. Okay? This is the 87th contractor in the whole nation. And the US government owes to AT&T 11-digit amount. I'm reading it 629,937,452.22. That is 0.1442% of the total amount the US government owes to AT&T. So this company is untouchable. You understand? This company is untouchable by the US Department of Justice because they are afraid of the powerful corporation. Now, folks, Scott Harris, as the chief clerk, was required under the rules pursuant to the court's order to investigate this guy, Scott Harris. So I had no recourse. So I approached the office of the Disciplinary Council. Close up this, please. I'm reading from the letter. Harris /David, undocketed case number 2018-U667. Well, they are not assigning a case number, undocketed. The letter reads, Dear Mr. David, this office has completed its review of the disciplinary complaint that you filed against Scott S. Harris, Esquire, the clerk of the Supreme Court of the United States. You state that Mr. Harris did not act on your concerns and refused to submit your motion after the court dismissed your case. You are also concerned that Mr. Harris is refusing to discipline his staff or follow his duties. We decline to open full investigation of this matter because your concerns describe Mr. Harris' duties as an administrator of the court. If Mr. Harris declined to act on your concerns or submit your motion, this was part of his official duties, which included accepting or rejecting submission to the court. We do not have authority to determine whether Mr. Harris should have behaved differently under the circumstances. Accordingly, this matter is now closed. Thank you for raising your concerns to this office. This letter was signed by a senior assistant disciplinary counsel, Becky Neal. She is not the disciplinary counsel. Disciplinary counsel is somebody else by the name Hamilton Fox III. He is the counsel. But it doesn't go to the correct people. It goes to the peon, not to the boss. So they are disposing of on their own. Now, the duties of the clerk of the court is well defined in these rules. These are the rules of the Supreme Court of the United States. You got it? Okay. Now, Rule 1 of the Supreme Court rules, this rule, says here, close up please, this one. I'm reading, it's only 2 paragraphs, actually 3 paragraphs. Rule number 1, clerk. The clerk receives documents for filing with the court and has authority to reject any submitted filing that does not comply with these rules. I'm going to explain. Let me first read. Second, the clerk maintains the court's records and will not permit any of them to be removed from the court building except as authorized by the court. Any document filed with the clerk and made part of this court's records may not thereafter be withdrawn from the official court records, court files. After the conclusion of proceedings in this court, original records and documents submitted document transmitted to this court by any other court will be returned to the court from which they were received. Paragraph 3 says, unless the court or the Chief Justice orders otherwise, the office of the clerk is open from 9 to 5 p.m. Monday through Friday, except on federal holidays listed in 5 U.S.C. Section 6103. It's a short paragraph dealing with the duties of the clerk of the court. His job is purely ministerial to carry out what the court tells the clerk of the court to do, and not to question the court's wisdom by these two petty clerks, Jeffrey Adkins. Their job is to purely accept and carry out, unless if there is a problem. The problems generally are the page limit. The rules limit, you can only have X number of pages. Previously it was 40 pages, the brief, and if somebody did a 60-page brief, they can say cut down unless the court authorizes. That's one limitation. Then the font, what font has to be used, okay? These are the restrictions, unless you use abusive languages. These are the grounds upon which the clerk of the court or his deputies can return the papers back to the filer. Okay? Now lately, lawyers are authorized to file papers electronically. So if you are a lawyer authorized to practice law, the clerks will meekly accept it. When pro se litigants file, they look for so-called errors. But these two super idiots, Blarlock and Jeffrey Adkins, couldn't find anything. They are returning the paper. First, the woman is looking at the wrong case. That's not my fault. Second idiot, Jeffrey Adkins, returning the papers by limiting his reading line 1 only, without reading line 2, 3, 4, and 5, which authorized me to file the papers. Folks, now I wanted to take you back. What are the issues here? This is very, very important. This litigation started against these two companies called Michigan Bell and AT&T in the year 1982, after I got a right to sue letter from the EEOC. I will show you a copy of the EEOC letter. We will show you that, put it there. Okay. Now, in my complaint that I filed against AT&T and Michigan Bell, I had sought remedies under Title 7 of the Civil Rights Act 1972 and as amended later, and under ADEA, Age Discrimination in Employment Act, and later a claim under ERISA, and sought a jury trial. Okay? Now, this is the name of the game. This is the beginning. Now, when I filed the case in the court, pro se, acting as my own counsel, seeking $10 million damages from these companies, Judge John A. Reed, who is now dead, he denied the defendant's motion to dismiss. By then, I had hired a lawyer from Chicago by the name Cyriac D. Capel, born and brought up in India. He is a practicing lawyer in Cook County, Chicago. He appeared on my behalf. He was a well-known lawyer who had argued the case of former Indian Prime Minister Morarji Desai in a defamation case. So he is a big, well-known lawyer. Defendants attempted first to woo him, to bribe him. This is the beginning. This is the beginning of the game. The judge denied the defendant's motion to dismiss, and he proposed to conduct a bifurcated trial to determine a release the defendant had obtained from me under duress, coercion, and fraud. The release stated I quit the job. Folks, what the defendant did was, they offered me some money, which I said I don't want it. Then they called me and my former wife to a hotel in Disney World, Lake Buena Vista, and we had a meeting in the lobby. He said, I will give you $45,000, Mr. David. We said, we don't want the money, sir. My children are small. My youngest boy, who is a doctor now, is 3 years old at the time. My other girls, 7, 9, 11. My father, dependent father. So we said we don't want the money. The employer fired me in the invited presence of my former wife. Okay? Now, after filing, we went there for a picketing in France. It was on prime time television. Before we went there, defendants sent one of their undercover agents by the name James R. Williams to kill me, to my home. He always carried a gun at the time. I don't know whether he does it now, or whether he's alive, I don't know. So there was a commotion in the house, and my children, hearing the commotion, and my father came to the scene. He was ejected from my place. The purpose was to persuade me not to conduct a picketing, which we did anyhow. Now the judge ruled against the defendants. They want to bribe my lawyer by making him a judge in the Cook County, Chicago. I was sitting in his office at that time for consultation. He was on another phone line. His wife, Walsa, next room, doing some Xeroxing. So he told me, Mr. David, pick up the phone. And the call was from the Cook County, Chicago, Bar Council. They wanted to speak to Mr. Capel. Capel picked up the phone. He told them in my presence, not interested, and he hung up. You understand? This is a gimmick a major corporation in America is deploying. This is the tactics number one. Then they try to give him some cases on their behalf so that he can file the reply or responses or answers, whatever it is. He said he's not interested. He understood the name of the game. My counsel was subsequently murdered. Syria Capel was murdered. But before he was murdered, I had to discontinue his services because I was unable to pay huge retainer to fight a case against the mighty Goliath. After I took over, defendant used another tactics. Yes, their tactics was secretly hire a young woman, then 30 years old. Her name is Nancy Conway. She was born, according to my research, in 1953. Annie Conway was born on July 30, 1950. So in 1982, when she came on board as the counsel for the defendant, she was 32 years old. Good-looking, cheeky girl. Okay? Judge was 51 years old. Judge was born June 29, 1931. He was 51 years old. So defendant, what they did was send this smart girl, 31-year-old woman by the name Nancy Conway, who was a private attorney then, to the judge's home. You hear, folks? A judge conducting a trial. She was hired by the defendant as their counsel, and she is going to provide either sex or money or both to this 31-year-old woman. All of a sudden, the judge's attitude changes. I didn't know this woman was the judge's pet. Whether she slept with him, she brought money in cash, in a box, in a suitcase, I don't know. The judge started avoiding conducting hearing in the open court. Every time I went to the court, the judge will say, Mr. David, come to my chambers. You understand what is going on, folks? You are wise men and women in America. I want you to understand. A 13-year-old young chick going to the judge's home. She is going to see him at his home. He is coming to see her at her home. They were meeting in Atlanta in private. I didn't know at the time the hanky-panky going on here. But I begin to become suspicious. Judge will conduct only the proceedings in his private room. We had 2 or 3 status conferences before him. In one of the status conferences, the judge held that there is a tribal issue of material facts remain in the case. We'll show you the video, tribal issues of material facts. So, every discovery I sought was denied by this judge. Every discovery, each and every discovery. This is a fight, the discovery fight. Now I want you to put this one, they're all discovery documents. Okay? So let me see how many pages here. I had 36 pages previously. I have written, this was doctored by the court, subsequently rewrote, but 36 pages of full entry, okay? The first page sought jury trial. I was denied every discovery. In a fair game, both parties are to be given discovery. The defendant deployed tactics. Their objective was designed to delay the whole proceedings. And using this woman, this 31-year-old woman, Auntie Conway, to accomplish their mission. So, every document I sought, it has to go through the magistrate first. Magistrate will deny without any rational basis, then goes to the judge, judge will deny. He denied a right to jury trial. Okay, that's the first thing he did. He refused to conduct the trial as ordered in his April 7, 1983 order. Refused to conduct, absolutely no reason or basis for that. Then they put me in a situation where everything, every discovery I sought under the rules, under the Federal Rules of Civil Procedure was denied. He denied me a jury trial, first thing. The US Constitution says you have the right to a jury trial. In a Title VII, the US Constitution says you have a right to an ADEA case, Age Discrimination in Employment case. The Constitution says you have a right to a breach of contract. This judge denied everything. Then you have to go to the appeal court and the US Supreme Court, and everything was denied, allegedly denied. I don't know whether the Supreme Court has read or understood what is the situation, because everything goes to the clerk's office and you get a printout saying that the petition denied. You don't know. You don't see anything signed by the justices. You get a printout which will say you are denied, your discovery denied. Folks, then I began to become very, very suspicious of what is going on here. I didn't know at the time the relationship between the judge and this woman whom they have brought, who is the judge's close friend. You understand? The judge's friend is brought, was his law clerk previously, which they didn't disclose until then. I began to become very, very suspicious of what is going on in the court system. As a citizen of the United States, as a litigant, I have every right to conduct my own case. No lawyer will take a case against this company because every lawyer in America knows their predatory and dilatory tactics. So lawyers will give up. Normally, if you are involved in a car accident, the lawyers will chase you because they get 1/3 of the compensation awarded to the injured party or dead party's pays. But in a civil case, in a discrimination case, lawyers don't want to touch, especially when a federal contractor who is doing with the business with the DOJ, because they have the opportunity, the ability. Now, there's a collusion between the judge and this woman with the defendants. So, I started my own investigations. I found out the hanky-panky going on between the judge and his former law clerk, Miss Conway. I sent the judge a questionnaire, 20 questions, seeking information from the judge. I sent 20 questions in a questionnaire and I submitted this in writing to the judge. Oh, as soon as the judge got this, he called me on the phone. A sitting federal judge calling a pro se litigant living in New York from Orlando, Florida. First his law clerk called and he said, Mr. David, Judge Reed wants to speak to you. I asked, Judge Reed? Yes, Mr. David, Judge Reed from the United States District Court in Florida. I got the phone that said, Mr. David, I got your questionnaire. I'm not going to answer this in writing. I will give you answers over the phone. How do I know what he is telling is true? He can reject it. So I sought his permission to have this tape recorded. The judge willingly admitted. This is in the records, in the court's records. According to page 25 of the docket sheet of the Middle District of Florida, dated 8/6/1984, it shows status conference by telephone conference call, read the court responds to certain questions propounded to the court by plaintiffs relating to the possibility of financial interest and or conflict of interest. That is what is stated there. Okay, that's page 25 of the docket sheet. Now, what the judge is doing is, he is telling me in the telephone conversation, he has some interest in the case. First, he is a shareholder of AT&T. He had worked for a subsidiary of AT&T, namely Southern Bell Telephone Company, before he became a judge. Second. Third, he has met this woman, Annie Conway, at his home. Annie Conway has met the judge at his home in Orlando, Florida. He also has met this woman in Atlanta at a private place. What more you needed, folks, to show the hanky-panky going on between this 31-year-old woman and the 51-year-old judge. Okay? As soon as this judge admitted this, made this confession, I notified the FBI and Chief Justice Warren Burger of the Supreme Court then. Is that long time ago. As soon as Judge Warren Burger got this, he directed Judge Reed to recuse from the case and possibly to resign. So, Judge Reed recused from the case, okay, after denying me my discovery request and transferring the case from Orlando to Tampa on 8/10 after the conference. The taped telephone conversation, judge issues several orders. Everything is discovered. Plaintiff motion for district court's review of magistrate's order denied 8/10. Plaintiff's motion for district court's review of magistrate's order filed 12/1983 denied. Plaintiff's motion to strike defendant's answers to request for admission filed 1984 denied. Defendant's motion for sanctions filed 2/17/84 ruling deferred. Plaintiff has 15 days to file a response, after which time the court will rule on the motion. 5. Plaintiff's motion for expenses of the defendant's motion for suppression filed 5/11/84 denied. 6. Plaintiff's demand for jury trial filed 1/18/84 denied. And the reference number R50D 891 CTC Reed J EOD 810/84. So, the name of the game here is bring in the judge's clerk. They meet in private in secret, which is unheard of in the annals of civilized litigation. And judge and this woman keep this as a closely guarded secret. Oh, on 8/28, Annie Conway files a motion, an affidavit, which reads, response to plaintiff's motion to disqualify. She says she never denies she met the judge. She says she didn't discuss my case. So what she was doing, okay? Woman going to see the judge, the trial judge, at his home, her home, they're meeting in private, and she said she didn't discuss. So she went there for sex and exchange of money to the judge, not to conduct the trial. Folks, that's the fun. So these records are with the court. Anybody can obtain this from the court. I have written myself to get a copy of it. So the name of the game was the judge recused from the case, and he unilaterally transferred the case to his buddy from Orlando to Tampa. At the time, folks, I was living in New York after a divorce from my first wife. I was actually staying with a friend of mine as his guest. The judge sends an order, Judge Hodges. He sends an order to me, Mr. David, come down to a conference before me. Being a court's order, I went from New York to Florida, although I was unemployed at the time. So, on the notice board, there is a notation. Additional security is required. As if I am a wanted criminal in a criminal case. Folks, this is a civil case. Title 7 of the Civil Rights Act, ADA claim, a claim for breaches of contract. I am not a wanted criminal. I didn't have a parking ticket then, to my credit, not even a parking ticket. I was cleared by the FBI to get a job with the federal government. I went to work for the Internal Revenue in Miami Appeal Division. Okay? So, I have nothing. No record. Absolutely nothing. So, the notice board says he needs additional security for a status conference with this judge, who has no personal jurisdiction or geographical jurisdiction over somebody who never lived in Tampa. I lived 90 miles away in Orlando. He can't have jurisdiction over me, somebody who lives in New York. When I went there, I had the FBI agents, deputy marshals, courtroom police, they are all in mufti with a gun, some of them carrying openly. They are surrounding me, both sides, all these sides. I am sitting in front of the judge. I told the judge, Your Honor, you have no jurisdiction over me. I live in New York. Transfer the case to New York. He says, no, Mr. David, I am the chief judge. I am the king. I can do no wrong. He, by force, assert jurisdiction over somebody who lives maybe 400 miles away. No, not 400. From Orlando to Miami, I think around 900 miles. I don't know, that's not the distance. I told the judge, Your Honor, I made a motion in standard. He says, no, Mr. David, this case is assigned to me. I'm going to conduct these proceedings. When I look at the court's records, there is a motion filed, which I didn't know at the time, but I found out there is a motion filed asking the court to transfer the case. He denies. Judge Hodges denied the motion. I live in New York, and the corporate defendant AT&T had their headquarters also in New York at 119, I believe, Broadway, New York. They moved, they kept moving their headquarters from one state to the other. They moved to Michigan subsequently. They merged. A lot of things happened. Now currently they are in California. So, no hearing. This judge says, I am going to conduct these proceedings in accordance with the standards and the parameters laid down by Judge Reed. Does he do it? No, folks. This sucker judge, it's all crooks. The whole team, they are all gangsters. Gangsters. I call them mafia. They beat the Costa Nostra and the Genovese, all these mafia families. The tactics of this corporation is so disgusting. Okay? I was buried in discovery process. This book, this is a book I kept. This was written somewhere. So discovery request. This whole book. I get no discovery. You understand? This is a fair game. You don't have to fight. They have to give it to you. Everything you ask, except those who are covered under attorney-client privilege. So their objective was to maim me, not to give me what the Constitution says I should get it. A jury trial. They don't want to give me. They don't want to give me discovery. They want to have the case dismissed. Now, according to the Judge Reed's order, the only issue before the court was the validity of a release, a 2-page release. The release says I quit the job. The court has to conduct a trial before a jury to determine whether Mr. David left his job on his own free will or fired. So every evidence is against them. So the tactics, now the defendant's tactics, they shifted. Now they are not talking about the validity of the release. They told this judge, this sucker judge, Terror William Hodges, this mafia judge, don't do anything. It's all under the deal table, you know. So he keeps quiet, do nothing. Okay? In the meantime, this sucker company, this mafia company called AT&T, fired another employee is a division manager by the name Orville E. McDonald. He was a division manager. He was from Michigan, well like me, and he was working for AT&T in New Jersey. They fire him and give him $12,000, and Mr. McDonald, this whole scheme, well orchestrated scheme. He files an action in the state court, not in the federal court, in the Michigan state court. And the Michigan state court rules Mr. McDonald must tender back the consideration paid to him before he can sue. Okay, so they're keeping my case in a state of suspended animation, doing nothing. No hearing, no trial, no bench trial, no discovery, nothing. As soon as this Michigan court judge issues a per curiam unpublished order and opinion, the defendant's counsel, Annie Conway, and Pete Sinover, the lead counsel, file a motion telling the court, Your Honor, Mr. David signed a release in Michigan, and under the Michigan law, the plaintiff must tender back the consideration to the employer after 5 years after I got the money. So, this puppet judge, no hearing, no trial, no pleading, as soon as he gets it in flagrant violation of Rule 56 of the Federal Rules of Civil Procedure, he issues an order right away, drawing his facts from his hat. If you didn't file any papers before this judge, no opportunity for me to oppose the motion, he cannot do anything. The rules say there should be a notice, there should be a time and place for the hearing after exhaustion of discoveries. No discovery, no notice, no nothing. As soon as he gets it, he issues a 5-page order. You'll see 5-page order dismissing the case without prejudice. He says, if Mr. David didn't tender back the consideration to the employer within 2 weeks from the date of this order, the case will be dismissed without prejudice. Mark the word, without prejudice. Now, I didn't know at the time the difference between a dismissal without prejudice and a dismissal on the merits. Under the scheme, it's all scheme, the clerk, deputy clerk of the court by the name Donald Brown, altered the court's order as a dismissal on the merits. You understand? I didn't know the fine difference between a dismissal without prejudice and a dismissal on the merits at that time. I asked many lawyers subsequently, when I was working in several law firms, they don't know the difference between a dismissal without prejudice and a dismissal on the merits. During my lunchtime, I happened to read the Law Journal one of those days in 1990. So, before I go into this issue, I moved, after this judge issues this order and the clerk alters the court's order as a dismissal on the merits, thinking that's the end of the matter, I filed a notice of appeal. I submitted the fee, the $70 and the docketing fee to the Court of Appeals. And after I filed my brief, excuse me, no, it's okay. After I filed my brief, the clerk of the court issues an entry of judgment dismissing the case January 9, 1985. Okay. Now, I filed my brief in the Court of Appeals. The clerk of the Court of Appeals, under the rules, required to ensure the case comes under the appeal jurisdiction of the High Court or the Court of Appeals. So it's all paid money under the table. So he determines this is an appealable order. Mr. Sinover, Pete Sinover, Annie Conway, and the defendant's entire in-house counsels filed a jurisdictional statement telling the appellate court it has jurisdiction under 28 U.S.C. 1291 in that plaintiff seeks review of a final decision. See that we're going to show the video, the order. So the Court of Appeals accept the case. I get an order from the 11th Circuit telling me to appear before the court for oral arguments. I flew in from New York to Atlanta for a 5 minutes argument, 5 minutes. They set the time in advance. I argued the case before a panel of 3 judges. The courtroom was packed with maybe 300 lawyers from big law firms. I am the first, perhaps the only pro se litigant. I argued the case to the best of my knowledge, not raising the lack of jurisdiction of the lower court or the appellate court, because I didn't know them. The panel of 3 judges affirm, A-F-F-I-R-M, affirm, one word, okay? The 2 judges in the appeal court, one was Robert Vance. He was bombed and murdered by another litigant. You can see Leroy Moody. He's the one who sent the bomb to kill the judge. Second judge, Clarence Allgood. He took a gun and shot himself. Folks, United States Court of Appeal for the 11th Circuit. Strange things happening. If you are a practicing attorney, find out what is going on in that court. Okay? It's a corrupt court, corrupt panel. You understand? I moved to the Supreme Court. My case number was 86-6168. Before the Supreme Court, the same lawyers, Pete Zinneber and Annie Conway, argue in paper saying that the court's decision of the Tamba court is an interlocutory order. So, the court has no jurisdiction to hear the case. They are telling the Supreme Court, telling the 11th Circuit it has jurisdiction because of a final order, telling the Supreme Court it has no jurisdiction. So, Supreme Court denied certiorari in the year 1986, October term. Folks, that's not the end. I took it for granted that's the end of my Title 7, ADA and ERISA claims and breach of contract claims, 3 of them. The ERISA claim was added later on when I reached my 65th birthday in the year 2006. Now, I filed an action against the defendants seeking my ERISA benefits. ERISA means Employees Retirement Income Security Act. It's a law passed by the Congress. Oh, defendants deploy another tactics. So all scheme, under the table scheme. The case is assigned to a judge appointed by President Clinton. Her name is Joanna Seibert. So, what the defendants do is, you have to understand the political connection, how they accomplish their mission using the Charlie's Angels. The defendant goes and hires the chairman of the Democratic Party's Rules Committee. It's a major international law firm by the name then known as Fulbright and Jaworski. Its chairman they hire. Why they want such a powerful lawyer? Because they want to manage everything under the table, bribing them. My investigation showed that law firm had paid $25,000 to the party election. I think Obama or whoever is then. That's another thing. Now, what the chairman does, he calls a newly licensed attorney who just got licensed from St. John's in the year 2006. Says his name is Brian Wayne Tilker. Okay, this is all going through party politics, not in a court of law for enforcement of the laws passed by the Congress. purely on party political basis. Now, this guy, Brian Wayne Tilker, files a false and perjured attorney affidavit. You will see a copy of his 3-page attorney affidavit, sworn, notarized attorney affidavit. Now, in his affidavit, this guy says, I am an attorney licensed to practice before the courts, and I work for the law firm of Fulbright and Jaworowski. I submit this affidavit knowing that I have full knowledge. I have personal knowledge of the facts stated here. This is the affidavit begins. Mr. Tilker, who is licensed to practice in the year 2016, who just graduated from St. John's in 2006, he filed a false and perjured attorney affidavit. The first page, which reads, Brian Tilker being duly sworn deposes and says, 1. I am an associate at Fulbright and Jaworowski LLP. I submit this affidavit in support of the defendants, Michigan Bell and AT, in this motion, collectively as the defendants, for summary judgment, a motion to dismiss. I have personal knowledge of the facts stated here. This is what he's saying on first paragraph. He has personal knowledge. He also states how the defendant obtained a judgment from the Tampa court, which was affirmed by the United States Court of Appeals and US Supreme Court denied certiorari. These are all his personal knowledge affidavit. The fact of the matter is, when I investigated Tilker, I learned from the Unified Court System records in New York that he was born on May 5, 1979. May 5, 1979. So at the time when I signed a certain release in Detroit, Michigan, on August 25, 1981, Tilker was only a child of 2 years old, 2 years, living in New York, in his diapers. He is testifying before a federal judge. He has personal knowledge about Mr. David executing a release in Detroit, Michigan on August 25, 1981. He was committing perjury. And all the statements he made, that he has personal knowledge about the obtaining a judgment from the Tampa court, affirmed by the 11th Circuit and certiorari, was also equally fraud, because the court's order, the Tampa court's order, was to dismiss the case without prejudice if plaintiff didn't tender back the consideration. That was the court's order. But the deputy clerk, Donald Brown, had on his own altered the court's judgment order as a judgment on the merits, which is not in the court's order. He does it on his own, and for doing this crime and other crimes, he was fired by the court, Tampa court itself, at the instance of 2 other judges, Kendall Sharp and Patricia Fawcett, finding him incompetent. So the incompetency of this clerk, Donald Brown, was carried forward to the next court, and the counsel for the defendant, Ann Conway and Pete Zinaber, filed a false jurisdictional statement telling the appellate court that it has jurisdiction, which its own clerk, Miguel Curtis, accepted for gospel truth, and accepted the case and ordered the petitioner and the defendants to come for a 5 minutes oral argument. Okay? The name of the game at the 11th Circuit is far more complicated and fraud, that they can fix any judge of their choice to have the case or any case of their party's interest by bribing them. Judge Robert Vance, who was murdered in the same year by one Mr. Leroy Moody. He sent a bomb to the judge and he was murdered. First judge in the panel. Second judge, Clarence Allgood, who committed suicide by shooting himself with his own gun. It's all top secret. And the murderer of Robert Vance was executed a couple of years ago after 38 years of trial, big fight. So you have to understand, folks, what is going on in the court below, in the New York courts, the Atlanta court, all over. I can write volumes. It will take months to finish up the corruption mill at full swing. Now, finally, this judge, Seibert, granted the motion for summary judgment from New York court to the defendants based on Tilker's false and perjured attorney affidavit, which was submitted by the political party's chairman, Ralph Curtis Dawson. I referred him to the Bar Council, and a 5-judge panel of the Appellate Division Supreme Court ordered an investigation against Dawson because the first judicial department, by a motion, asked the court to transfer the investigation against Dawson to any other disciplinary committee other than the first, because Mr. Dawson is a member of the disciplinary committee himself. So a 5-judge panel issued an order ordering Mr. Dawson to appear before it and for the second judicial department to conduct an investigation in an unpublished order, confidential M2138 on June 8, 2012. Folks, there's a court's order, 5-judge panel order. Did the second department in Brooklyn conduct an investigation against the party chairman? No, folks. The second department, they're all Democrats. They hushed up. So the 5 judges order gone with the wind. Okay? And the Supreme Court allegedly denied certiorari. It went through the Court of Appeals. I didn't know at the time the fraud, all the things going on. Folks, now we were filing after motion after motion. One more thing I forgot to mention. I referred the matter first to the Department of Justice, and on May 22, 2012, my appendix came. Preet Bahara, who was the United States Attorney, and David J. Kennedy, Chief Civil Rights Unit, denied an investigation against these 2 criminals, that is Tilker and Ralph Curtis Dawson, and their concluding paragraph says, we have carefully reviewed the information that you submitted. Based upon the information you have provided, we have concluded that the facts you described do not appear to implicate a violation of the federal civil rights laws over which this office has jurisdiction. The conclusion does not represent an opinion as to the merit of any individual claims that you may have. Please be advised that your letter or complaint to this office has no effect on any statute of limitation that might apply to your claim. By sending a letter or filing a letter of complaint with this office, you have not commenced a lawsuit or a legal or administrative proceeding, and this office has not initiated a lawsuit or a proceeding on your behalf. So what the department, Preet Bahara, the United States Attorney, who was fired by President Trump, is saying is, Tilker committed a crime and Dawson, but in their view, it is not constituting a crime. Okay, an attorney filing, a 2-year-old child filing a false affidavit in a federal court, and judge grants a summary judgment based on his affidavit, citing the same at 12 places in her impugned order and judgment. The U.S. attorney says he has not done anything wrong. Folks, you have to understand, this is a political game carried on by the Democratic Party. From one player to the other, all the way. Folks, I don't want to prolong the argument here. Finally, I filed a petition. Before filing the petition, I I obtained a amended judgment from Judge Hodges. What is the reason for getting an amended judgment? I found out while working in another law firm the difference between a dismissal without prejudice and a dismissal on the merits. And I told the court, the Tampa court, your order was to dismiss the case without prejudice, which is not a final order. The clerk had altered it on his own, so the judgment of the court should be vacated. The Judge Hodges, by an amended order, issued a direction to the clerk of the court to amend the judgment. Okay? I think it's on January 30, 1991. So when the court issued an amended order reiterating that its prior judgment was without prejudice, which is unappealable, I moved the 11th Circuit Court of Appeals to recall mandate under Rule 35 of the Federal Rules of Appeal Procedure. That rule says you have to submit certain statement as required and should move the court to vacate or recall mandate, which I did. It was rejected by J.L. Edmondson, although he had ceased himself as an active judge of the 11th Circuit as from July 15, 2012. The motion was submitted to the court on sometime in 2015. So by then, Judge Edmondson had ceased himself as an active judge of the circuit to 3 years earlier. Although Rule 35 of the Federal Rules of Appeal Procedure states that should be heard by a 3-panel judges, three active panel judges, it doesn't go to 3-judge panel because they know they are going to hold in my favor. There are so many case laws decided by the US Supreme Court and the various Circuit Court of Appeals, including in the 11th Circuit, that when a court lacks jurisdiction, its judgment is a nullity. I have cited on page 24 through 31 of my new brief which I submitted, which they rejected, these reasons why the court should recall mandate. Folks, I submitted a second motion. It only goes to Judge J.L. Edmondson only, as if he is the only judge in a 31 judge court. Okay, some of them are active, some of them are inactive. The rules require, Federal Rules of Appeal Procedure 35 requires the case be heard by 3-judge panel, if not by the en banc court. It doesn't go. It goes only within the players. The players in the same political party. Folks, Judge Edmondson and Marcus, they denied holding my second motion, FRAP 35 motion, is a reconsideration motion. I never used the term reconsideration. Okay? So the tactics, they don't want to give it to a 3-judge panel, active 3-judge panel. They have to decide the case by a judge who is disqualified by their own rules. I brought this matter to the attention of the circuit executives, and he justified the retired judge dealing with this matter. It doesn't make any sense. That is also one of my attachments, which you will see in this video. Folks, then I moved to the US Supreme Court for the umpteenth time, seeking review of this matter, telling the appellate court the court had no jurisdiction. Courts below, the Tampa Court and the Court of Appeals at the 11th Circuit, the judgment was altered by the clerk of the court to make it appealable, and citing all the case laws decided by the US Supreme Court and the Circuit Court of Appeals and the 11th. I'm told, you have to listen folks, the name of the game is between the players and the clerk of the court, Scott S. Aris. and his deputies. So I'm getting a printout saying the court denied. When the court holds, the Supreme Court of the United States determined in several cases when a court has no jurisdiction, how can they say in this case the court has jurisdiction? Folks, you have to understand the problem here. It's not a political game. You don't know whether the justices of the Supreme Court, the 9 justices, or their law clerks have seen this. This is the clerk manufacture. Okay, he put the things in the computer, put the name of the plaintiff and the respondent or defendant, and print saying that the court denied. You have any means to verify? Absolutely no way. Whatever the clerk of the court is telling you through their agents, that is what you are communicated, you are dealt with. Folks, I didn't rest there. The court allegedly denied my petition for a writ of mandamus to the 11th Circuit in case number 15-9100. Folks, after the court allegedly denied my petition for a writ of mandamus, I filed yet another one. That's the case number 16-9624, 16-94. In that order, the court held on October 2, 2017, that my petition to proceed in form of pauperis is denied as well as my motion. But on line 3, 4, 5, the court says, unless Mr. David files the petition pursuant to the rules and pay the docketing fee, which is what exactly I did. Folks, what happened to us, as soon as I filed this, one super idiot, super clerk, her title is shown as a legal analyst employed by the Supreme Court Clerk's office by the name Melissa Blarlock. She returns the old papers back to me, telling me to comply with the court's order, which is what exactly I have done it and what she has in her hand, along with the money. I obtained a check from bank draft from my bank, ICICI Bank in Trivandrum, made it payable to J.C. Morgan in New York, payable. It's a bank draft. You have seen that. So she returns. She cites their case number 15-9100 instead of case number 9624. She is looking at the court's order, but she is doing something different. Okay? I tried to call this woman so many times, she won't answer the phone. I left messages for her and her supervisor by the name Jeffrey Atkins to return my call, toll-free number from USA to India, which is 1-631-841-6222. That's my New York number, which I carried with me when I came to India. They won't call. Then I sent the check, the same bank draft which this woman returned, to Chief Justice Roberts, requesting him to direct the clerk's office to assign a case number, a docket number. Okay? Chief Justice in turn forwarded it to the clerk's office. I'm getting a letter from Jeffrey Atkins, second time, not first time, from him first time, dated February, let me see it here, the letter from, on October 2, 2017, the court dismissed a petition for a writ of mandamus in case number 9624. This case is considered closed in this court. Your papers are returned herewith. Your 300 check is herewith returned. That's his letter. This second super idiot employed by the US Supreme Court. He should have read the 5-line order of the court in the court's October 2, 2017 order, which he doesn't want to read. He knows English, otherwise he wouldn't be a super analyst employed in the Supreme Court of the United States. I wrote to the clerk again, clerk of the court, Scott Harris, in reply to that letter, on April 10, 2018, I get another letter which is shown as P5. P5. The letter reads, Dear Mr. David, in reply to your letter of submission received on April 9, 2018, I regret to inform you that the court is unable to assist you in the matter you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases or controversies properly brought before it from lower courts in accordance with the federal law and filed pursuant to the rules of this court. Your papers are returned for the reasons stated in the January 17 and February 16 correspondence. So this idiot, super idiot, Jeffrey Atkins, doesn't want to read the court's order. He only wants to read line 1, ignoring line 3, 4 and 5 which authorizes me to pay. So he is returning that letter, the money back to me with this letter. Then I wrote to the chief clerk again. So he is playing different tactics. Then on August 10, that's my P6 exhibit, what he is doing is, apparently when I set the missionaries in motion, they started an investigation on August 10, 2018. He is returning all the papers I submitted, including the brief for the second time on July 30, 2018. The reason why he did this was he doesn't want to keep any papers in the court's records. The rule 1.1 of the Supreme Court rules say the clerk is required to keep all the papers in the court's records until the Supreme Court orders. So without telling the investigator, whoever is investigating, he is shipping them back to me. Oh, there's another interesting thing. This letter didn't come to me for 4 months and 17 days later. We have the envelope in which it was sent, it was franked, sufficiently adequately stamped. So this may be an insider job. Okay, I don't want to go into, because that's not the issue here, how he is covering his ass. Okay, he keeps the papers there. When the investigation started, he goes maybe to the United States Post Office, tell them frank it backdated. So they sent it a few days before, sometime in December, although the franking shows it was mailed on August 12. Okay, from the clerk's office with a cover letter dated August 10. It reaches India after 4 months and 17 days later. Fraud, that's a fraud. Folks, I brought these matters to the attention of the US Department of Justice numerous times. They kept the file. Now, on March 4, 2019, I get a letter from the Department of Justice. This is the letter, P7, marked P7. In the letter, US Department of Justice says in an unsigned letter, Dear Mr. David, thank you for your correspondence received on December 12, 2018. US Department of Justice, DOJ, Office of Inspector General, investigates allegations of misconduct by employees. Tilker is an employee and the clerk of the court. And contractors of DOJ, ATL is a contractor. As well as waste, fraud and abuse affecting DOJ programs or operations. The matters you raised are outside our investigative jurisdiction. Okay? Therefore, no action can be taken by our office. We are returning your material to you so that you may pursue your concerns in a more appropriate venue. You are telling the FBI, US Department of Justice, to investigate the judges, the clerk of the court, or the players. They say we can't do anything. Department of Justice, the FBI. Okay, listen, you haven't finished yet. The letter reads, you may wish to consult the website www.ignet.gov to obtain information for other federal agency inspector general. Please be advised that we have not retained a copy of your material and any additional material you submit regarding this matter will be destroyed. Of course, you have new information. If you have new information that involves other allegations or issues regarding DOJ employees, contractors, programs or operations, please feel free to submit that information to us. Thank you for giving us an opportunity to review your concerns. Sincerely, no sign, Office of Inspector General, Investigations Division. That is what the US Department of Justice is telling me, who are primarily involved in so many investigations against all employees, and federal contractors. Okay, but the clerk of the court and his two assistant clerks, they are not employees of the court, right? That's what the Department of Justice is telling me. Then I get another letter on April 11, 2019 from the same agency, P8. That letter reads, Dear Mr. David, thank you for your correspondence dated March 18, 2019. The U.S. Department of Justice, DOJ Office of Inspector General investigates allegations of misconduct by employees and contractors of DOJ, as well as waste, fraud, and abuse affecting DOJ programs or operations. That's what they say. Misconduct by employees and contractors of DOJ, as well as waste, fraud, and abuse affecting DOJ programs or operations. Next paragraph. The matters you raised are outside our investigative jurisdiction. Therefore, no action can be taken by your office. As a courtesy, your complaint has been forwarded to the following office: Administrative Office of the United States, Courts, 1 Columbus Circle, Northeast, Washington, D.C., 2002-3002. This office considers the matters raised by you in your most recent letter and in previous correspondence to be closed, and we do not intend to change the further correspondence with you regarding this matter. Again, unsigned letter, Office of Inspector General, Investigations Division. Folks, that's the U.S. Department of Justice saying, because this is a big cat, big, shark, so we can't investigate. Folks, I did further investigation. Here's a P9 exhibit. P9, 1, 2, 3. Now, in this one, it says 23 instances of misconduct since 1995 and 316.9 million in penalties. These are the cases in which the same agency investigated AT&T. Okay, they imposed 316.9 million damages. And there are many cases pending against the page 2. And also page 3, it says here on page 9, AT&T is the 87th contractor, 87th federal contractor to whom the US government owes, let me read the figures here, 629,937, 452, 0.22, which is 0.01442%. Okay, so AT&T is a contractor who violated the laws, various laws. They've been fined by the U.S. Department of Justice, but here they being a big fish and a federal contractor, the U.S. Inspector General of the FBI, DOJ, do not want to investigate. Folks, I wrote again to Scott Harris, the Chief Clerk, Scott Harris. He sends no reply to me. All the communication between me and Scott Harris is between these two clerks, deputy clerks. Primarily, Melissa Block only made one decision which is wrong, and I am told she has been either moved or fired. Now, the second idiot is the super Jeffrey Erkins. He is the main player here. The clerk of the court keeps quiet. He knew, he being a JD, a Jewish doctor person, and I think he's a Harvard, He knew what I'm talking about. He can read the court's 5-line order. After the chief clerk, Scott Harris, refused to answer to my questions and failing to read the court's October 2, 2017 order, I made a formal complaint with the Disciplinary Council of the DC Bar. Here is a copy of my response I received from the DC Bar, which reads, Harris /David undocketed number 2018-U667. Dear Mr. David, this office has completed its review of the disciplinary complaint that you filed against Scott S. Harris, Esquire, the clerk of the Supreme Court of the United States. You state that Mr. Harris did not act on your concerns and refused to submit your motion after the court dismissed your case. Court didn't dismiss, that's what they are saying. You are also concerned that Mr. Harris is refusing to discipline his staff or follow his duties. Paragraph. We decline to open a full investigation of this matter because your concerns describe Mr. Harris' duties as an administrator of the court. If Mr. Harris declined to act on your concerns or submit your motion, this was part of his official duties, which include accepting or rejecting submission to this court. We do not have the authority to determine whether Mr. Harris should have behaved differently under the circumstances. Accordingly, this matter is now closed. Thank you for raising your concerns to this office. This is my P10 exhibit. You can see the full text. This is signed by a woman by the name Becky Neal. Her title is Senior Assistant Disciplinary Counsel. My complaint is to the Chief Counsel, Disciplinary Counsel, Hamilton F. Fox, 3rd. So that's their conclusion. Then I read to them another letter saying that the clerk has no discretion because I complied with the court's order. There is no defect in my petition. He should have carried out his ministerial responsibilities pursuant to Rule 1 of the Supreme Court rules. So I'm getting another letter. This is P11. The P11 says, dated May 1, 2019, Mr. David, we received your correspondence requesting a second review of the disciplinary complaint that you filed against Scott S. Harris, Esquire. Our decisions are final and not subject to further review. See Board Rule 2.4. However, we have considered your request and there are no new facts sufficient to change our decision. Therefore, while we appreciate your concerns, we decline to reopen this matter, signed by the same woman, Becky Neal, Senior Assistant Disciplinary Counsel. Folks, as I repeatedly mentioned, the role of the clerk of the court is purely ministerial. He has no choice but to carry out the Supreme Court's commands. He can't question their wisdom, howsoever stupid or smart they may be. He has to carry out their commands, which he doesn't want to do, his two clerks doesn't want to do. Folks, the name of the game that goes on within the players of the same political party right up the Supreme Court of the United States Clerk's office. Folks, I had no option but to refer the matter to the United Nations, and the United Nations says they have no jurisdiction over America. Folks, what do I am supposed to do? 38 years I fought against this mafia corporation with the players, the political players passing the ball between themselves. Finally, I wrote to the United States Senate and the House of Representatives. Although 1.5 months have passed, I haven't heard I am ready and willing to testify. Congress, senators, representatives, what is going on here. If you allow the laws passed by you, namely Title 7 of the Civil Rights Act, ADA, Age Discrimination Employment Act, ERISA, then what you expect the people to do? They start bombing everybody like Leroy Moody did. Somebody has to do something. I'm an 80-year-old person. I'm in the last days or years of my life. I'm afraid to come back to America unless you give me protection. Okay, this mafia corporation may do anything like they did to Jamal Khashoggi in Saudi. I hope you gentlemen, ladies, you will rise to the occasion and then do whatever you are required to do. Oh, one more thing I forgot. The thing I forgot was I filed complaints against all these players, one after the other. Annie Conway, Peter Zinova, other attorneys who filed false papers. And I felt Judge J.L. Edmondson was the one who broke all the standards, because the court says, the court below says, we have no jurisdiction, this is only an interlocutory order, and he refused to recall mandate. He is a disqualified judge as from July 15, 2012. He gets a file purely on political basis, he denies. Then I got a letter, I sent a complaint to all the various agencies, every agency. I felt the one who committed the maximum crime was this judge, the lonely judge, J.L. Edmondson, and I submitted my papers to that committee, the Judicial Commission or committee investigating, and they sent me a letter, I responded to that. Then they said I have 48 days to respond to another thing, and that paper came to me after 16 days from it was originally posted by regular mail, and as soon as I got it, within the time permitted, I submitted my response. Now they say, I got a letter as I was preparing this video. The letter reads, Judicial Complaint number 11-18-90172 in the matter of a complaint filed by Clerical David. They don't say the name of the judge, it is Judge J.L. Edmondson, we all know. Which says, Dear Mr. David, on October 7, 2019, this office received from you a letter pertaining to the above. Reference to complaint of judicial misconduct of disability. According to our records, the matter of judicial complaint 11-18-90172 is closed. Please be advised, there is no provision in the rules of judicial conduct and judicial disability proceedings of the Judicial Conference of the United States for filing of such a document in a closed complaint of judicial misconduct or disability. Therefore, the document we received from you on October 7 is being retained unfiled. In addition, any documents received from you in the future pertains to a closed matter will not be filed. It's not signed by anybody. Signed, it says David S. Smith. Signed, not signed again, Christian Kinderly, Deputy Clerk, their phone number. So what is happening is, all the players involved, including Judge, now Annie Conway, the dishonorable judge, who was dealing under the table with the judge in collusion, and she was made the judge of the district court and the chief judge, and then transferred to the U.S. government surveillance court. She's off the hook. Judge Edmondson, who did it, off the hook. Colonel William Hodges, who committed the crime, who had no jurisdiction to start with, is off the hook. Every player is off the hook. This woman, I want the senators to understand, this woman who is a co-conspirator, Nancy Conway. She was the judge who wrote the judgment in respect of Carter Page. They should investigate first whether she is qualified, how she got clearance from the FBI. A co-conspirator doing hanky-panky with the federal judge gets promoted and she goes to the chief judge. She becomes the chief judge. Then as I started publishing this in the documentaries in the YouTube, she is transferred to the terrorist court as a judge. One of the judges sitting there until 2023. Folks, these are the things the Republican senators should investigate, should bring it to the attention of the court, attention of the Senate, the Congress. What remedy I have? An aggrieved person who was dismissed when he was only 42, 41, with a young family. Folks, if you gentlemen, wise men and women in America, whether you are a senator or congressman, you should look into all aspects of this case, all aspects. Okay, how the judge who is disqualified gets the case in the Court of Appeal, how a judge who is sitting in Tampa gets jurisdiction over somebody who lives in New York. Okay, how this woman, this co-conspirator, she gets promoted without any clearance from the FBI. Folks, we only live once. I don't live like a feared animal, like these judges, these crooked judges. I live like a warrior. Whether I get a day in court, 38 years, you have to ask yourself, what is the reason for a most powerful corporation on this earth can't give me discovery, can't give me a day in court? No hearing, no trial, nothing. Good day, gentlemen. Thank you. From Alina. I will put it on the time.